Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello, everyone, and welcome to Immigration Talk with Attorney Anish. It is January 24th, 2019, and we'll be talking today about the residency requirements relating to naturalization. Thank you for tuning in and for listening to this radio show. I use this platform to discuss common questions I receive in the course of the consultations that I conduct for potential clients and in the course of the services I provide to my existing clients. If you want to have a more personalized and unique consultation that pertains specifically to your situation, please give us a call. Area code 323-592-9980. Again, that's 323-592-9980. We have two offices, one in Los Angeles and one in the Bay Area in the city of Fremont, California. But we provide services to everyone worldwide who have U.S. immigration concerns or issues or cases. If you want to schedule an appointment for the LA office, then the number to call is the one I gave, 323-592-9980. If you want to schedule an appointment for the Fremont office, call area code 510-585-3990. Again, that's 510-585-3990. If you go to the website, www.lawfirmav.com, you'll see that we have an 877 number. That's fine too. That number is 877-227-9714. Again, that's 877-227-9714. If you'd like to contact us through that website, then click on the Contact Us link and fill out the inquiry form and submit it. They all come to me directly. I read them all. You can also email me directly at consult@lawfirmav.com. That's CONSULT at LAWFIRM, and then my initials, A as in Apple, V as in Victor.com. So today is about the residency requirements for naturalization. So I want to give a few caveats first. I'm not going to be saying whether or not you should apply for naturalization. I'm simply going to be laying out the residency requirements for naturalization. If someone has deportation history, criminal history, fraud history, then I always suggest that they talk to an immigration lawyer first before deciding to take any course of action. But if you don't have any concerns and you don't want to speak to an immigration lawyer, I understand. But you do need to know about the residency requirements, particularly if you travel a lot or if you've been moving around a lot, because they could make you ineligible and you may not know until you get to the interview, and you'll be disappointed. There are three main residency requirements. I'll be discussing them. And for purposes of this podcast or radio show, we'll be focusing on people who are applying under the 5-year rule, meaning that they've been permanent residents for at least 5 years. If you're married to a U.S. citizen and you've been living with that U.S. citizen for 3 years, and your marriage has been at least 3 years long, then you potentially could apply under the earlier rule, which only requires you to wait 3 years. But if you're going to be applying under the normal rule of 5 years, then I'll be focusing. Then this radio show will be focusing on those requirements. So when we say 5 years, what that really means is that starting from the date that you're approved for permanent residence, which means either the date you adjusted status or the date that you entered on an immigrant visa, then on the surface, you're allowed to apply for naturalization after 5 years. Now, when I say adjusted status, I don't mean the date that you did the removal on your conditions on residency was completed. I mean the date that you first got your conditional residence, if in fact you received conditional residence initially. So, counting from that date, you are allowed to apply for naturalization 4 years and 9 months thereafter. You don't have to wait the full 5 years, assuming you meet the residency requirements. So, the first residency requirement I would call the continuous residence requirement. And that requires that you have been residing continuously in the U.S. for 5 years. Again, you can still apply at the 4 year, 9 month mark if you can meet this continuous residency requirement. What is that requirement? That requirement means that you have not taken any trips longer than a year outside the U.S. You could have multiple trips that equal more than a year, going combined, but you cannot have a single trip that's over a year. That automatically resets the clock. And it resets to a 4-year and 1 day clock, not a 5-year clock, but 4 years and 1 day from the date you return from that trip that's longer than a year. There are also shorter trips that can cause problems, and but that's for anything between 6 months and a year. Anything longer than 6 months but less than a year probably is going to be a problem unless you can, what they say is, rebut the presumption that you had an interruption in the continuity of your residence. How does one rebut the presumption? Show that that you never actually gave up any type of residence in the U.S. How does one show that? You show that you didn't quit your job in the U.S. You show that you didn't take up a job outside of the U.S. You show that your immediate family remained in the U.S. and you show that you continue to have full access to your residence in the U.S. Now, if you quit your job and you start working for a company outside the U.S. and you have no family in the U.S. and you were renting out your house or apartment in the U.S. while you were gone, it's going to be hard to rebut that presumption. But if you took a trip and you got sick or you got hurt and you had to remain abroad for longer than 6 months but less than a year, then and you didn't take up a job outside the U.S. and you continue to have full access to your home here in the U.S. and your family remained in the U.S., then you have a good chance of rebutting the presumption. Unfortunately, if your trip lasts longer than a year, even if it's beyond your control, there's no argument that can be made. You have to wait 4 years and a day from the date that you return. Similarly, if you cannot rebut the presumption for a trip that's between 6 and 12 months, then you have to wait 4 years and a day from the date you return from that long trip before you can be eligible to apply for naturalization. Before you can be eligible to be granted naturalization, you can always apply. You're always eligible to apply whenever you want. Doesn't mean you're going to get it. So that's the continuous residence requirement. I don't want people to be confused with the with abandonment of permanent residence, which is a slightly different issue, and that's whether you can even keep your green card in the first place. So just because U.S. Customs and Border Protection may let you in even if you took a really long trip and they allowed you to keep your green card, that doesn't necessarily mean that you remain eligible to obtain citizenship or naturalization. So the analysis is a little bit different, and just because you are allowed to enter after a trip longer than a year doesn't mean that you are eligible to receive U.S. citizenship immediately. Let's move on to the next residency requirement, and we'll call it the physical presence requirement. And this is the one I get asked about a lot because the calculation of it is not necessarily so easy. But on the to try to make it easier for people to understand, you have to basically show that during the 5 years, again, just like the continuous residence requirement, it's 5 years going backward from the date you apply for naturalization. You have to show, for the physical presence requirement, to show for 5 years going back, you have spent most of your time here in the U.S. So that's half of the 5 years. That's 2.5 years. You have to show that you've been physically in the U.S., not continuously, not consecutively, but when you count up all the days, you spent most of that time, most of those days here in the U.S. And the number of days that you have to show is 913. Because half of 5 years is 912.5 days. If you can show that you've been here for 913 days, then you meet this requirement. So the question I get is not how many days do I have to be in the U.S. The answer is easy, 913. But the question I get is, okay, well, I don't have that. When can I apply? The answer to that question depends on whether or not you plan to take any more trips. And I can't simply add the number of days you continue to remain here to the number of days you have, because I have to count backward from the date that you plan to apply. So it's almost like a guess and check type of analysis, where I have to think about what date that you're planning on applying and then look backward 5 years to see if you spent most of your time during those 5 years in the U.S. And if you plan on taking any other trips, then I need to know how long those trips are planned to be, so that I can make sure that they're not included in the calculation, and that I don't add them on accident to the number that will get me hopefully to 913. So that's the physical presence requirement. Like the continuous residence requirement, there are some exceptions. I'm not going to go into those exceptions for people who are in the military, people who are working for U.S. Enterprises abroad, people who are working for certain religious organizations, people who are married to such people. Those are all exceptions that may apply to you, but whether or not they apply, we'd have to discuss that in a more formal consultation setting. I don't want to get into the details of that because it can be confusing, especially when only one person is communicating via the radio show, and I cannot get simple answers to simple questions that help me determine whether any of those exceptions apply. So moving on to the last requirement, and that's usually the easiest, but a lot of people don't quite understand it. It's the requirement that you spend at least 90 days in the same area of the country in which you apply, and what people don't quite understand about that requirement is that it does not relate to the same city or even the same county. What it mostly pertains to is the USCIS district. Now, some USCIS districts cover a whole state, and that's easy. So as long as you continue to live in the same state, then everything's fine. But in a state like California, where you have multiple USCIS districts, you have the San Diego district, you have the LA district, you have the Sacramento district, and you have the San Francisco district. The district that you reside in may not be the same one that you move from. And it doesn't mean field office, because, for example, the LA district has 5 field offices: San Fernando Valley, Los Angeles County, Santa Ana, and Riverside. San Bernardino. So if you move from an address that's within the jurisdiction of San Bernardino to an office that's in the jurisdiction of the San Fernando Valley field office, that's fine. You're still within the same LA district. It's as if you were to move from the Bay Area to the LA area within the last 3 months. Then you'd have to wait until you were residing in the LA area for at least 3 months or 90 days before you become eligible to receive naturalization if you were to apply. And that's pretty much it when it comes to the residency requirements. Again, we didn't talk about good moral character. We didn't talk about admissibility, deportability. We didn't talk about abandonment, other than to say that it's different than the continuous residence requirement. There are a number of issues to look at when you're dealing with naturalization, including the ones I just summarized but didn't discuss in detail. You also have to make sure that you received your permanent residence lawfully, because sometimes that happens where people receive a green card, but it's an error, and they don't know it until they apply for naturalization. And USCIS, upon adjudicating the naturalization application, looks a little bit more closely to someone's basis for obtaining permanent residence and finds that an error was made, and that can become a pain. But as far as residency requirements, I think I summarized them pretty well. I would say that if you're applying under the 3-year rule, then you can apply 2 years and 9 months after you get your green card, or after you've been admitted as a permanent resident or conditional resident. And you can also prove that you meet the 3 years of continuous residence requirement rather than the 5 years of continuous residence requirement. And you have to prove that you've been physically present for 1.5 years in the U.S. instead of 2.5 years. So those requirements basically get cut in half. You still have to prove that you've been residing in the same place for 3 months. You don't cut that in half if you're applying under the 3-year rule. And just to be clear, when I say half, I'm talking about the physical presence requirement. For the continuous residence requirement, I know that 3 is not half of 5, so it would be 3/5 of the normal rule. But for physical presence, instead of showing 3 years or 2.5 years of physical presence, then you need to show that you have 1.5 years of physical presence if applying under the 3-year rule. So that's also not in half either. So I take it back. Nothing is cut in half by switching from the 5-year to the 3-year rule. I'm glad I was able to do that math quickly in my head. But that shows all the more reason why you need to really sit down with a pen and paper and add up all the days you've been in the U.S. and add up how long each trip outside the U.S. has been before deciding to apply for naturalization. Anyway, this is Attorney Anish with Immigration Talk with Attorney Anish, and I hope that you subscribe and you follow my not only my radio show but my blog posts and the updates to the website to give you the latest information regarding what's happening in U.S. immigration law. And thank you very much.